Project Veritas, this was one of the first stories that I ever covered from Project Veritas. And you know what? I know that I can show this one because I won't get a copy strike for playing my own content. Viva, Frei, Project Veritas, bird dog. I think this should bring it up. Oh, you son of a gun. I'm not in the right. Give me 2 seconds, people. Going to go to the search engine. Going to put it in. Boom, shakalaka. Oh, it has to be a very old video. I'm going to go filters and go upload date. Upload date. Sort by upload date. And I'll just put Viva Frei Project Veritas. It was one of their original, oh gosh. Do I want to go back to cringe content that I once upon a time produced? I'm looking for the original. It was Directed Verdict. Here we go. 2 years ago, I think this is it. Yeah, Directed Verdict in the defamation lawsuit. So they were sued for defamation, unlawful trade practices, whatever. Oh my goodness, people, get ready for cringe, and I'm already a little nervous. This was in our old kitchen, in our old house, and my goodness, do we see this? Okay. Let me know what you think of this. Does Putin have an active Twitter account? Help settle a bet. Thanks for the video. I don't know. I don't follow him. If that was the underlying joke, people, this is me. One cannot be cringeful of what they are because that's who they are.
Veritas and James O'Keefe was recently the defamation lawsuit filed by one Shirley Teter against Project Veritas and James O'Keefe was recently dismissed, and it is impossible to understand what exactly is going on unless one understands what a directed verdict is.
Can't do it. Can't do it. I can't do it. Oh God, that's. Bring it out. Bring it out, people. That was what I looked like a long time ago, and I can look back at my own content, and I can look into my eyes at the time, and know when I was not fully comfortable and fully at ease, sitting in a house talking to a camera. I can tell, and I remember roughly when I just got comfortable treating this camera like it's a human eye. Oh God. Ugh. Anyway, oh yeah, here. Did I already put the link in? You can go here. I'll go. You can go watch that if you want. I'll put it in afterwards. Oh my God, yeah. Well, the question is, do I look? I don't care about cute. Do I look younger or older now? Have the last 3 years? And by the way, it says it was posted 2 years ago. That was June 10th, 2019. That's going to be 3 years ago this June. Who would have thunk things could have become what they are? But that, I mean, it's totally, life is absolutely bizarre. So this goes back to that vlog, life being an amazingly coincidental, miraculous circle. Back in the day, this woman named Shirley Teter was at a Trump event, and I'm going to stop sharing. And there was an incident where this woman alleged to have been assaulted by another individual named Campbell. And Project Veritas did an expose where they determined, obtained evidence that Shirley Teter, or Teter, or Teter if it's in French, that she was what's called a bird dogger. I had no idea what the word meant. And that is apparently someone who goes to political rallies, is funded, financed, or motivated by activist groups. They go to political events to raise a poo-poo, to make a stink, so that it can then be weaponized by the media to go, to demonize the event, the politician, or whatever. Kind of like the wrap-up smear, but in person. So I'm just going to pull up an article which describes what it was, because we'll get the backdrop. Not the 5 monkey experiment. Judge dismisses. Well, this will explain the story. ABC 13 News. Judge dismisses libel suit by Asheville woman following 2016 Trump rally. This is from May 22, 2019, before I covered it in a vlog. A federal judge has tossed a lawsuit by an Asheville woman who reported an assault outside a 2016 Donald Trump campaign rally. Shirley Teter filed a lawsuit against conservative group Project Veritas, James O'Keefe, and affiliate Project Veritas Action for defamation, claiming her portrayal in a Project Veritas video ruined her name. Remember what the ultimate defense to defamation is, at least in the States and in Canada, but not in Quebec. Truth is the ultimate defense. Teter claimed the group portrayed her as a political activist sent to a 2016 Trump rally to cause chaos. Then we get into the incident. Shirley Teter, who lived in a senior housing apartment a block from the cellular center, was among a group of protesters outside the rally. Teter told to police that she was assaulted following the rally. A South Carolina man was arrested for the assault, but charges were later dropped. Soon after the incident, an online video was released by O'Keefe. Gosh darn, if anybody is doing the Lord's work of journalism, it's James O'Keefe and Project Veritas. Soon after the incident, an online video was released by O'Keefe and Project Veritas claiming to show Democratic operatives planning to incite disorder and violence at Trump rallies. We reported accurately what Scott Fovel, the politically affiliated operative, told us, says O'Keefe. Fovel was the director at the time for a liberal political group called Americans Unite for Change. In the video, Fovel says she was one of our activists, what had been trained up to bird dog. What had been trained up to bird dog. What's unclear is who Fovel referring to in the video. Teter denied being a political operative. Teter sued Project Veritas, James O'Keefe in the national court. They say they've defamed her, yada, yada, yada. O'Keefe countered, saying the lawsuit was really an attempt to shut down his conservative voice. I believe this is an attack on the First Amendment and press in general by people who politically disagree with us. And then he won a what was called a directed verdict. And let's do it while we're here. On Wednesday, May 22, 2019, U.S. District Judge Martin Redinger dismissed the lawsuit. A portion of it went to trial, which was dismissed by a jury, and that's what's going to get us here. The First Amendment protected Project Veritas. Is there anything relatively interesting here? No. That fine line has to be walked, yada, yada, yada. Okay, if Judge Redinger ruled Teter's lawsuit didn't present clear and convincing evidence that there was actual malice, O'Keefe's attorneys contended Teter was required to prove actual malice because she became a public figure. There's the expression for a public figure for a specific incident after speaking to news media about the assault. What was it called? Hold on one second. There's an expression, public figure, special figure. Special figure, is that what it is? What's the example? Chat, you're going to get it faster than I'll get it. What's the expression for someone who becomes a public figure for one specific incident because they decide to speak out or, do something illegal and get arrested? Chat, let me do it before I go. I don't want to, let me see here. While we're there. No, not special prominence. It's not special prominence. Limited purpose public figure. Sorry, I think that's it. So I think it's a limited purpose public figure. Someone who comes out, for example, to speak against an incident. Someone who gets arrested for DUI in a massive accident becomes a limited purpose public figure. I am throwing $20 to get the afro shaped up. It's getting a little wild. I'm going to use that $20, at the very least the 70% that comes to the channel, to buy massage oils for my scalp that will help it grow faster. But thank you very much. Limited purpose public figure. So Shirley Teter became a limited purpose public figure. They said a portion of your claim is dismissed outright by the judge. Doesn't even go to trial. The other portion of her claim went to trial. The verdict unanimously dismissed her lawsuit. Sorry, I almost knocked over the camera. Her lawsuit was dismissed and she was ordered to pay costs. And what ended up happening? Project Veritas files I think it's called a bill of costs in the United States. They filed a bill of costs. It's like $22,000. And Shirley Teter says, I can't pay it. I should be dispensed from paying it because I don't have the money. And it's undue hardships for me to pay the costs of the lawsuit that I filed. And the special clerk, I believe, granted the decision to dispense Shirley Teter of having to pay the costs of her failed lawsuit. Project Veritas takes that decision. It's not to appeal. They take it to a judge, and we'll see in the lawsuit. But the decision is de novo. The judge who adjudicates on whether or not Shirley Teter be condemned to pay the costs and legal fees. I think it included legal fees. The judge adjudicating on whether or not Shirley Teter be ordered to pay the costs, it's de novo. From scratch, no deference to the clerk's decision to not order it. The judge takes it de novo and says, yeah, no, you're paying these costs. Your statement under oath in your affidavit that you don't have the funds to pay this doesn't really make much sense, because it doesn't make much sense based on your own testimony, based on your own financial situation. So let's just see. It's another great decision by Project Veritas, where they get a lawsuit dismissed on a directed verdict. They then win the decision on the merits. They then get an order to pay costs, and I think it included legal fees. The plaintiff who filed the frivolous lawsuit, who was arguably, but maybe not so arguably, a political operative bird dog, as revealed by the secret recordings, gets ordered to pay costs, tries to get out of it, saying, "Oh, poor me, I don't have the money to pay for my lawsuit." The clerk, who I guess, gets inspired by pity or just, got the wool pulled over his or her eyes, it goes to a judge and the judge says, "No, you're going to pay. And here's why." If Hunter was able, no, that's it. Oh no, I have to go to this. Okay. And hold on. I got to do this. Then I've got to bring up the PDF and then I can see it. And I believe this is it. I believe I can share now. And I'm going to share the whole screen. There's a highlighted section, but we'll get there in a bit. I will not be able to see chat, people. I don't like that. I don't like that view. Hold on. Okay, I like this view better. And let me just make sure that, okay, we're seeing it. So here we go. United States District Court, and this is Shirley Teter plaintiff versus Project Veritas. Memorandum and decision of order. Background, we don't need to go into it. 2 lawsuits filed, in light of that incident. She sued the other guy also for assault, and they settled that out of court. I don't know how that ended. Okay, we don't need to go over the facts yet again. In the companion case, plaintiff and Mr. Campbell, this is the assault case, entered into a confidential settlement and dismissed their respective claims and counterclaims. Each was accusing the other of assault. We don't know how that settled. It's a confidential settlement, but Shirley Teter and the individual whom she accused of assault and the individual who claimed Shirley Teter assaulted him, they settled their suit. Yada, yada, yada. In the present case, the court entered an order for granting summary judgment in favor of the defendants on the claim of unfair and deceptive trade practices, and the parties proceed to trial by jury on the remaining defamation, libel, and slander. I can't highlight this. Following the close of evidence, the court determined that the defendants were entitled to judgment as a matter of law on the plaintiff's claim for defamation, libel, and slander. Thus, the court entered the judgment. Wait, no, when did she get to Oh, it didn't go to the jury. I'm an idiot. Following the close of evidence, the court determined that the defendants were entitled to judgment as a matter of law on the plaintiff's claim for defamation, libel, and slander. Thus, on June 7, 2019, the court entered a judgment dismissing the plaintiff's action and including a provision that the defendants shall recover their costs of the action from the plaintiff. Okay, well, wrong case. No jury then, I guess. Hold on one second. On July 2019, the defendants filed a bill of costs seeking $23,000 from plaintiff. Plaintiff objected to the bill of costs, arguing, first, that she's unable to pay the defendant's costs, and in the alternative, that some of the specifics sought are unrecoverable. So here, I'm operating on the basis that this is, let me just go back here and bring this out. Stop screen. I'm operating on the basis that this is similar to Quebec, Canadian law, where you get your bill of costs and it's got everything broken down. It includes stenographer fees, transcripts, service fees, filing fees. And if someone gets it and they say, look, I don't agree with this amount. You shouldn't have charged me for 4 copies of your transcript. You should have only charged me for 1. Or I don't think you were entitled for whatever. So she says, no, they're claiming things that I don't have to pay, and therefore it should be dismissed. And then the judge says, no, what happens is Project Veritas revises it and resends it, and they reduce it by a certain amount. Let me see if I can bring this back in here. And then if we go here, do we see it? We see it. So in the companion case, no, we were already there. On August 16, 2019, defendants filed the revised bill. So they reduce it from $23,924 to $23,143. Plaintiff objected to the revised bill on the same grounds. Okay. And then the clerk of the court issued an order denying defendants costs because, quote, the financial circumstances set forth in the sworn affidavit are sufficient to overcome the presumption in favor of awarding costs to defendant as the prevailing parties. Now, bear in mind, it was the judge. I don't know if there's a procedural mechanism that allows for recovery of costs, but the judge specified. When the judge dismissed the action, it said the defendants shall recover their costs of the action from the plaintiff. shall and not may. So I presume that the judge is not so happy with the clerk, who seems to be overriding the judge's shall with their own determination. Standard of review, and then this is the legal criteria for standard review, and I believe it says de novo somewhere here. Federal rule, yada yada yada. It says it was de novo. Where did it say de novo? Novo. I can't even find it here. Novo. There we go. Cost de novo. The court's reviews of the clerks is denying costs. It's de novo. There's no deference. There's no nothing. It's from scratch, and the judge decides it. Let's just get to some of the highlighted sections because it's quite funny. Here, by the way, this is what she says in her affidavit. In support of her argument, plaintiff submitted her bank records from January through December of 2019 and an affidavit signed by the plaintiff in August 2019 detailing her monthly income and expenses. In her affidavit, she states, I have no money to pay for defendant's litigation costs. I had or have no money to pay my lawyers the costs and expenses they incurred on my behalf in representing me. My lawyers did not agree to pay the costs and expenses they incurred on my behalf, and they certainly did not agree to pay any award of costs incurred by the defendants. I guarantee you the lawyers did not agree to that. But unfortunately, when you file a suit and it's dismissed by the judge or a jury, sometimes you have to pay because you're the losing party. In Quebec, it's excessively difficult, barring a statutory provision to recover legal fees. It's exceptionally difficult in Quebec, but elsewhere, it's the rule. Losing party pays. But I love this. While the plaintiff attests in her affidavit to having no funds with which to pay the defendant's costs or the costs incurred by her own attorneys, upon questioning on the February 25, 2022 hearing, plaintiff's counsel acknowledged that the plaintiff had received a substantial payment from Mr. Campbell. She had received a substantial payment from Mr. Campbell in January of 2019 as settlement in the companion case. It's always curious when people pay, but sometimes people just pay to avoid a trial. I mean, and in a case of alleged assault between an elderly frail woman and Mr. Campbell, who I believe was not an elderly frail woman, but a man, there might be risk factors in going to trial. There might have been facts that I'm not familiar with the assault incident itself. He might have been guilty, paid her a substantial settlement of money. But she says, I have no money, but I got a substantial payment, or at least her lawyers say it, in the companion case. That's not going to fly too well with, her candor before the court. Plaintiff's counsel further explained that half of these settlement funds were used to pay plaintiff's attorney's fees, some of whom represented the plaintiff, both in this case and the companion case. So just bear this in mind, people. She says in an affidavit, I don't have the money. That's 2019. It turns out that she got a substantial settlement payment, and her lawyers, who can't lie to court, have to admit it, but that went to pay her lawyers. So, she gets to sue someone frivolously to the point where the judge dismisses it on a directed verdict. And then her lawyers say, well, that settlement went to me. She doesn't have money to pay them. And they're going to say, yeah, well, she had the money and she decided where it went. One was a court order that she was ordered to pay because she lost her suit. The other was her contract with you. If she doesn't pay you, that's contractual. If she doesn't pay the court, that's not respecting the court order. Therefore, when the plaintiff submitted a sworn affidavit to the court saying that she had, quote, no money to pay my lawyers the cost, she was less than fully candid with the court. By the way, when someone says, when the judge says you were less than fully candid, that is legalese respectful court talk to say you're a damn liar. We caught you, and you don't lie to the court and think you're going to get away with it if you get caught. The records in the present case presents very unusual circumstances regarding the plaintiff's ability to pay the cost and her responsibility for such costs. Plaintiff's receipt of a substantial sum in the Campbell settlement also does not fully explain the plaintiff's financial arrangement with plaintiff's counsel. The plaintiff was represented by 6 attorneys in this matter. The plaintiff, who has no money, who's not a political operative by her own affirmation, was represented by 6 attorneys in this matter, all of whom were from outside of this district, and one of whom was from out of state. That's curious. 4 of these attorneys were present for the entire trial. This is a woman who claims to have no money to pay the costs she was ordered to pay, who has 6 attorneys, 4 of whom are present for the entire trial, even if they were charging a ridiculously low hourly rate, assuming it's 10 hours a day of work and court time. That would be $2,500 a day. Times 4, that would be $10,000 a day of lawyers, one of whom's from out of state, present for Shirley Teter, who doesn't have money to pay $20,000, but has this money. You suspect Shirley Teter, to quote Ben Affleck from Good Will Hunting. 4 of the attorneys were present the entire trial. The plaintiff had the sort of representation not ordinarily available to litigants in her position. I wonder why. Could it be because these lawyers, I'd love to know, I don't know who they are. I'd be curious to know if they have any affiliations to any political organizations, any not-for-profit activist groups. In the court's experience, there are only a few scenarios where multiple out-of-town attorneys would be willing to become involved in representing a plaintiff who, by all accounts, is indigent and therefore cannot pay the costs of the litigation itself. What might people think those cases are? And yeah, so that's it. Thus, the involvement of so many geographically diverse attorneys is a matter that is puzzling to the court. By the way, legalese, when a court says it's puzzling, what they're basically saying is, you're a liar. You expect us to believe your lie. Your lie makes no sense, and we don't believe your lie. It's puzzling. But the courts are more polite than Viva. After all, the plaintiff's claim was so weak that it did not survive a motion to dismiss at the close of the evidence. Further, whatever, this we already talked about. Further, Mr. Sasser only raised more questions by his unsolicited statement, specifically disclaiming that the lawsuit was being funded by the Clinton campaign or the Democratic Party. That was not the question that the court asked. However, Mr. Sasser, what's the context on this again? Oh yeah, Mr. Sasser did not explain, however, why 6 out-of-town attorneys would agree to take Ms. Teter's case on a primarily pro bono basis. Moreover, Mr. Sasser did not explain why, once the Campbell matter was settled, that these attorneys continued to represent the plaintiff on a contingent fee basis. After all, the plaintiff's claim was so weak, yada, yada, yada. And yeah, the court knows what's going on. The court knows exactly what's going on. And then, bottom line. So these are the costs that go into it, but it doesn't matter. The bottom line, I'll have to post this, find a way to convert this into a link. Here are the costs. These are the costs that go into what they're getting. Witness fees, fees of service of subpoena. These are all things that typically, they're court costs. But they do add up, and they add up quickly. You got all of these expert fees and so on and so forth. Okay, $15,000. Because the defendants seek costs for some items that clearly fall outside the scope of recoverable costs, yada, 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 it's revised. It will be a total of $7,000. It will be revised. It will be reduced by $7,000 to $15,000. And so it is therefore ordered that the defendant's motion to review clerk's order denying costs is granted in part. It's revised, vacated. The clerk of this court is instructed to assess the cost, yada, yada, yada. And they're ordered to pay $15,000. Delete copy. Is that going to do anything? So in summary, people, I missed all of the chat while that was going on. In summary, people, Shirley Teter had such a frivolous case, it was dismissed. She entered into a settlement that was an undisclosed confidential amount with the individual she accused of assault. She attested to court that she didn't have the money to pay her attorneys when her attorneys were compelled to disclose to the court a substantial settlement that was paid to her by the other individual while she was simultaneously claiming financial hardships so that she did not have to pay the costs incurred by Project Veritas et al., who she frivolously sued for a baseless accusation. The court then pontificates as to how this, what did they say? What was the word? They didn't say insolvent, but they basically were implying that. The court then inquired how it is that 6 attorneys, some of whom are out of state, would represent an individual who didn't have the money to pay them, 4 of whom attended every day at court, saying there's only very, very exceptional circumstances in which attorneys would agree to do this pro bono. And then there was some offhand affirmation that, there might be some political connections here. None of it made sense to the court. The court sniffed it out like it is, sometimes does properly. And now Shirley Teter is going to have to pay $15,000 to Project Veritas, down from what Project Veritas was asking for in their bill of costs. And knowing the way fake news media is going to spin it, they're going to probably try to spin this as though it was a defeat for Project Veritas and a victory for the plaintiff. Project Veritas asked for $23,000 and a court denied that request and only granted them $15,000. But when you read that, oh, my goodness, very interesting stuff and very fun stuff. So another W for Project Veritas. There was an L, at least a temporary L, with respect to their defamation lawsuit against CNN, but another W. So chalk it up to people who fight the good fight. They fight the good fights as plaintiffs and they defend the good fights as defendants. And, the bird dog has left the nest, I guess. All right, that's that.